Week 2. This lecture is about the European Union's competence to make law and take legally binding acts. In order to answer a problem question like this one that we looked at last week, involving a dispute about this is not a problem question. In order to answer a problem question involving a dispute about the EU's competence, or an essay question like this one that we looked at last week, you need to have a clear understanding of the following things: the principle of conferral, the types of competence, exclusive or shared, the specific sources of competence or legal bases in the EU treaty and the legislative procedure associated with each, and the constraints on competence, subsidiarity and proportionality. You will also have to understand the jurisdiction of the Court of Justice of the European Union in terms of judicial review of European Union law. Who can bring a claim, the locus standi, when must a claim be brought, and what are the grounds of review. In addition, in order to answer an essay question using these topics, you'll need to understand the lawmaking process in the EU, relations between the EU institutions and citizens of the EU, like elections and so on, relations between the EU and the member states, and how the EU measures up in terms of democratic lawmaking. So questions like legitimacy and accountability that we talked about last week. So these multimedia lectures continue to guide you through developing that understanding. Please keep careful notes, as you'll need these for the workshops and for your eventual module assessment. Again, we will be adopting a pedagogical approach that stresses active rather than passive learning. And we're offering plenty of virtual support. Please do be in touch. It will be lovely to see you virtually by any of these means. If all else fails, email me and we'll sort something out. Okay. So let's begin with the principle of conferral. I'd like you to open a copy of the Treaty on the Functioning of the European Union and turn to Articles 4 and 5 of the TEU. And then watch this very short 2-minute video. It's just a sound file. Welcome back. So, there is a narrative of the European Union acquiring more and more competences over time, this idea of competence creep. And this is an element of the arguments to the effect that the European Union lacks legitimacy. But actually, we need to problematize this narrative. Really, there are at least four elements, that interact in the story of European Union competence. There is the fact that the member states amend the foundational treaties that give the EU power over time. Second, there is the legislation accepted and adopted by the European Parliament and Council, which of course represent the European population and the governments of the member states. Thirdly, there is the way that courts in the European Union and courts at EU level and at national level in the European Union have interpreted EU competence. And finally, there is the question of how the other EU institutions, the Parliament in particular, but also the Council and the Commission, have interpreted their competence. Throughout our learning about the principle of conferral, we need to distinguish between two different elements or types of competence. First of all, we need to think about the distinction between express power and implied power. So express power, both express and implied power can be legally disputed. There can be a dispute over the extent of an expressly granted power. The candidate case here, which you'll be studying further in your workshops, is the tobacco advertising case, in which the Court of Justice of the European Union held that what is now Article 114 TFEU, the power to create and sustain the EU's internal market, an area where products, services, people and capital may move as freely as possible. The Court of Justice of the European Union held that aspects of the original tobacco advertising directive did not create and sustain the internal market because they did not create a cross-border market or remove appreciable distortions of competition between companies providing services, here advertising services, in different member states. Note that the European Commission subsequently revised the Tobacco Advertising Directive, and the revised version was accepted as competently adopted. There can also be a dispute over whether a particular treaty provision implies a power to act. So the Court of Justice of the European Union has accepted that the existence of an explicit power implies the necessary powers to exercise that implied power since the 1950s. But the European Court of Justice has also accepted that where a provision of the treaties confers a specific task on the EU institutions, it must be implied that the treaty also confers the powers which are indispensable to carry out that task. This was established in a case involving Germany and the European Union's migration policy back in the mid-1980s, concerning the power of the European Commission to require, by decision, that the Member States inform the Commission of their policies on integration of non-EU citizens into the social and cultural life of their countries. This principle was confirmed in a later case involving environmental crimes in 2005, which concerned a framework decision, a type of law that pre-existed the Lisbon Treaty, so that we don't need to bother learning about that type of law at present. A framework decision that required member states to impose criminal liabilities for certain environmental offences. In more recent cases, the European Court of First Instance has stressed that this is an exceptional rule, the implied powers, the broad concept of the implied powers rule. It's only applicable where implicit powers are essential to ensure the effect in practice of the relevant EU measure. As well as distinguishing between express and implied power, we also need to distinguish between internal and external competence. External competence refers to the European Union's powers to enter into international obligations or international agreements with non-EU countries. As we're not covering this topic in this module, except to note it in the context of Brexit, for now, just be aware of the existence of external competence. Our focus here in this module is on the European Union's internal competence, the power to adopt European Union laws, regulations and directives, and to take decisions, formal binding acts of EU law, according to Article 288 TFEU, as well as to take non-binding acts like recommendations and opinions that govern the European Union's internal affairs. Now, Article TEU is the starting point in terms of the European Union's rules on competence, but we need to turn to the Treaty on the Functioning of the European Union, which sets out the main categories of competence. So if you would now turn to Article 2 of the Treaty on the Functioning of the European Union, I see there's a typo on this slide. It should be Article 2 TFEU, not Article 2 TEU. So Article 2 TFEU sets out the main categories of competence, and these are elaborated in the provisions that follow in the Treaty on the Functioning of the European Union. So if you look at Article 2, it says that where the treaties confer on the Union exclusive competence in a specific area, only the Union may legislate and adopt legally binding acts in that area. And the member states can only do that if the European Union gives the member states power to do that, particularly to implement those acts. When the treaties confer on the Union a competence that's shared with the member states in a particular area, the Union and the member states may legislate and adopt legally binding acts in that area. The member states can exercise their competence to the extent that the EU has not exercised its competence. And if the Union decides to stop exercising its competence, then the member states can exercise their competence again. Then there are further provisions in terms of the Union providing arrangements through which the member states coordinate their economic and employment policies. There are particular provisions in the treaty about the Union's competence to define and implement a common foreign and security policy, including the framing of a common defence policy. In some areas, and under the conditions that the treaties lay down, the Union has competence to carry out actions to support, coordinate, or supplement the actions of the Member States without superseding national competence in those areas. And in those areas, the legally binding acts of the Union may not entail harmonisation of national laws or regulations. The treaty goes on to explain the different types of competence in more detail. So I see the typo is continued in here. It should say Article 2 TFEU on this slide. So exclusive competence is in a list of areas, and it's an exhaustive list of areas set out in Article 3.1 TFEU. So the Union has exclusive competence in the areas of the customs union, competition, necessary for the functioning of the internal market, monetary policy for the Euro member states, conservation of marine biological resources under the common fisheries policies, and the common commercial policy, which is the EU's external trade relations. Article 3, subparagraph 2 goes on to talk about the Union's exclusive competence for concluding an international agreement. This needs to be looked at alongside Article 216 TFEU, which we will cover later in the module when we talk about the EU's developing relationship with the UK. The list in Article 3.1 is unconditional, but there's still scope for dispute about the boundaries of the relevant fields. It's a very limited list of areas that we have here in Article 3.1. The Union's power to act on its own is very tightly constrained, and this adds to arguments about the European Union's legitimacy. If we think about this in terms of input legitimacy, then this is a very good thing. But if we think about it in terms of output legitimacy, we might see it differently. So the list in Article 3.1, there's still scope for dispute about the boundaries of the relevant fields. Is, for example, a law about customs, quotas and tariffs part of the customs union, or is it discriminatory taxation part of the internal market? So, for example, the Court of Justice held in the Gauweiler case that a programme in which the European Central Bank purchases bonds issued by Eurozone states from a third party, this falls within monetary policy, not economic policy. So it did fall within the exclusive competence of the member states. The European Union's most important competence provision is arguably the competence to create and sustain the internal market. And this is in the list of shared competences in Article 4 TFEU, which you should look at now. So shared competence applies in a longer list of areas, and the internal market heads up the list. So if we go through that list, it's the internal market, it's social policy for aspects defined in the treaty, economic, social and territorial cohesion, agriculture and fisheries except for marine biological resources, which of course is in exclusive competence, environment, consumer protection, transport, trans-European networks, energy, the area of freedom, security and justice, and common safety concerns in public health matters, again for the areas defined in this treaty. And then in subparagraph 3, in research, technological development and space, there is shared competence, but the exercise of that competence mustn't result in member states being prevented from exercising their competence. And there's a similar rule for areas of development cooperation and humanitarian aid for third countries. So again, there are boundary problems between shared competence and the other two main areas of competence, exclusive competence and power to take supporting, coordinating, or supplementary action. And this boundary was at issue in terms of the European Union's response to the COVID-19 pandemic. So the Treaty on the Functioning of the European Union clearly states in Article 168 that Union action in the field of public health has to be supporting and complementary to national policies. The European Union may adopt incentive measures, but it may not harmonise national laws. But as I've argued in a paper with Kai Pernhagen and others, the hyperlink to which is on the slide, incentive measures could, for example, include reinforcing measures already required by existing European Union law, such as reporting obligations under the Union's early warning and response system for pandemics, including, for example, sharing personal data necessary for contact tracing. The requirement for interoperability of systems would amount to de facto something very close to harmonisation of national approaches, even though this would be an incentive measure in terms of the competence rules. Article 2, subparagraph 2 of the TEU provides, of the TFEU, that should be, Article 2, subparagraph 2 of the TFEU provides that in areas of shared competence, member states are preempted from acting. Article 2 of the TFEU, I'm having another go at this, provides that in areas of shared competence, member states are preempted from action once the Union has exercised its competence. And again, this rule sounds simple, but the devil's in the detail. In order to understand where the EU has exercised its competence, we have to look closely at the detail of the relevant laws and what exactly they require. Do they require minimum harmonisation, exhaustive harmonisation, a reporting requirement, many other possibilities? It's not the case of a blanket rule. And this is reflected in the Protocol on Shared Competence, which explains that shared competence only covers those elements governed by the Union Act in question and therefore does not cover the whole topic area. But the principle of conferral always sits behind the way the doctrine of preemption operates. Let's look at another example from the health domain, pharmaceuticals marketing. The way that the European Union understands shared competence in that domain is illustrated by a case called Doc Morris from 2003. This slide has a picture of the Doc Morris internet pharmacy. The dispute arose in the context of an online pharmacy offering products and services across the Dutch-German border. Several measures of European Union legislation were at issue, including consumer protection legislation about electronic commerce and the European Union's Code for the Marketing of Pharmaceuticals, which was originally established in the 1960s in response to the Globid thalidomide tragedy. That European Union law, now Directive 2001/83 as amended, requires that member states put in place a system to prohibit placing on the market of pharmaceuticals that have not been authorised for sale in the European Union. Germany had done that by means of domestic legislation which prohibited sale of pharmaceuticals online. The online pharmacy, established in the Netherlands and compliant with the Netherlands implementing law, which permitted sale of pharmaceuticals online, wanted to sell to the German market. The Court of Justice of the European Union held that German law was consistent with EU internal market law as it applied to the general marketing prohibition. The relevant European Union consumer protection legislation permitted member states to adopt a higher protective standard, as Germany had done, by prohibiting the sale of authorised pharmaceuticals other than by physical pharmacies. Where a member state does so, however, that national measure must comply with internal market law. The court found that the German rule restricted trade in the internal market. It was justified in the case of prescription-only pharmaceuticals on the grounds of protecting public health. but it was not justified for pharmaceuticals that were available direct to the patient without prescription. This case is not directly about competence, but in its reasoning you can see the ways in which shared competence works out in practice. The union rules preempted some national laws, ones which in effect divide up the internal market in unjustified ways, but they did not preempt all of national law. There are special rules about union competence in economic, employment and social policy and in the common foreign security policy and defence. In the former area, there is a union process through which the member states are obliged to report on and coordinate their economic and employment policies. This works through something called the European semester, an ongoing process whereby member states share information about their economic, labour and social policies and are supposed to learn from each other to improve things. The idea comes from the OECD, and it's part of European Union law because the member states have not agreed to harmonise or even come close to harmonising those parts of domestic competence. You will see that there are boundary disputes between this area and areas of internal market law, like on free movement of labour and services, later on in the module.